I think today we should focus on our clients who are on their 485s. Could be in the beginning of their 485s or towards the latter part, because I think that's a very decisive visa because it only has 24 months on that particular visa, and then clients sometimes really struggle to kind of strategize their pathway towards PR once they're on that visa. Do we have any interesting stories that we can share with our clients?
Last year, I helped a client who was in a very tough spot.
So basically, when it comes to the 407, do we still have that 1 year requirement, or is there some alternative option that we can use?
So obviously, you can go into a 482 visa with one employer, and then if you find another employer who is willing to sponsor you on a 482, you can move to them. But also at the same time, if you go into a 482 visa, you can only work for your sponsoring employers.
Also, I would want to know when will be the good time or like the best time that them, like the particular employee or clients, can initiate that conversation with the employer. Welcome to episode 6 of Visa Game Plan. Today the episode is going to be for all our clients who are on their 485 struggling to strategize their pathway towards PR. I have our immigration solicitor, Keith James, with me today. Keith, how are you?
Very good, Amasha. We are here in the final episode of our season 2. I think it's been a brilliant journey talking about all the various skill migration options the clients have. What shall we start with today?
I think today we should focus on our clients who are on their 485s. Could be in the beginning of their 485s or towards the latter part, because I think that's a very decisive visa because it only has 24 months on that particular visa, and then clients sometimes really struggle to kind of strategize their pathway towards PR once they're on that visa. I'm quite sure we've got plenty of clients who've come to us towards the latter part of their 485, and I'm quite sure we've helped them as well. Do we have any interesting stories that we can share with our clients?
Yeah, I remember last year I helped a client who was in a very tough spot. So she had basically started doing an early childcare teaching graduate diploma on the second year of her 485. So you know how the 485 is 2 years, right? So for the first 12 months, she had done something else. And then she decided, look, I want to start the graduate diploma of early childcare teaching. Now, when she came to us, we realized that her course will only give her the completion letter a few days after her 485 actually expires.
I see,
right?
Okay.
But she was already working at a childcare center at the time, and the employer had said, look, we'll sponsor you because we really like your work. But the problem was she couldn't finish the course before her 485 ended, so I didn't have a completion letter to lodge any visa. So what I had to do was I had to come up with this strategy where we lodged a visitor visa just a day or two before her 485 expired, and we got a bridging visa A. Now, this bridging visa was associated with that visitor visa we applied. So if the visitor visa was either refused or granted, we were going to have huge problems. Because if the visitor visa was granted, then the client loses work rights, and they usually grant a visitor visa for about 3 months at most, usually less if you're onshore. If it was refused, that will be an even bigger problem, because then the client will be barred by Section 48 of the Migration Act, which says that if you've had an onshore visa refusal, you can't apply for another visa. And the client would have had to appeal that refusal to the ART, and that would have been very difficult. So what I did was I lodged the visitor visa, waited for the bridging visa to become active, and I withdrew the visitor visa.
I see, okay.
When you withdraw an application, as long as you're on a bridging visa associated with that, you get 35 days, right? Now I had 35 days to play around with. Within that 35 days, I had checked with the client's university. They had said, yes, we will be issuing the completion letter. Now remember, this client studied their graduate diploma on the second part of their 485.
Second part of the 485.
Which meant that they didn't really have any work experience as an early childcare teacher.
Correct.
So in order to apply for a 485 visa, or a 482 visa rather, you need at least 1 year of work experience on a full-time basis in that occupation. So the only opportunity or the option I had for this client was to apply for a 407 visa.
So basically, when it comes to the 407, do we still have that 1 year requirement, or is there some alternative option that we can use?
Correct. So the 407 is one of the most flexible visas out there. It's still an employer-sponsored visa, but it's a training visa, which means you only need 12 months of work or study experience in the last 24 months.
I see, okay.
Right? So that client's 12 months graduate diploma that she studied on the 485, that gave the client the eligibility. So within that 35 days, I lodged a 407 visa, and then I got the client a bridging visa B to enable them to continue to stay in Australia.
That must have actually been a very strenuous process.
Correct. It required a lot of research on our end to figure the pathway out, and also like to give the client the confidence that, when you lodge a visitor visa, you get a bridging visa. You withdraw that, then you have 35 days left on the bridging visa.
To apply
Then we're
for
going to apply for
another
another visa. So
And the timelines are very tight as well, right?
correct. So it required a lot of communication with both the employer and the client because their stress levels are pretty high as well. But I'm glad to report that it worked out for that client, and we're well on our way to applying for PR for that client now.
Definitely. That was really fantastic work, Keith, in that
Yeah,
sense.
I know that it. Those type of challenging cases really make practicing migration law worth it. So yeah, I think that was a great example of some of the complex work we do here at MJ Legal.
Also, in one of your episodes, I saw that you've mentioned something about EOI ROI, and you've also said even though a client has applied for their EOI, doesn't mean that they have the tendency of getting invited. Let's say they've already lodged their EOI ROI and they're on their 485. What other options do they have while they wait for the invitation?
Yes, I think while you wait for an invitation for skill migration, what you can do is actually negotiate with your employer to get invited or to get an employer sponsorship.
This
right?
is basically for the 482.
482, 407, if you have 3 years of work experience,
The
even the
494.
186.
The 186.
Yeah,
the
the
direct
186.
entry or
The direct entry. The
Yes.
494 is more for
The
clients
regional.
working in the regional areas. But if you can get the 186 even from a regional area, I would recommend that.
That would be
because
great,
that's the
yeah.
PR, right?
Correct.
So let's talk about some of the strategies the clients can employ negotiating with their employer.
Also, I would want to know when will be the good time or like the best time that them, like the particular employee or clients can initiate that conversation with the employer.
True. So my recommendation always to clients in consultations is at the interview, don't tell the employer you want to be sponsored because some employers don't even know what sponsoring a migrant worker looks like. And for some employers who know the process, they know it's quite expensive. So what I would recommend you do is go to that interview, secure the job first, and start working there, pass probation, ensure that you are an exemplary worker, and then go and have that chat with your HR or your boss, right? And when you have that chat, if they sound a little hesitant, this is a good way to pitch it. Tell your employer that by sponsoring them, they get to secure your skills for the next 2 to 3 years because that's how long you need to work on a 482 visa.
So, which
right?
means the employee would have an obligation towards the employer in that sense, or do
Yeah.
they also have the possibility of changing it down the line?
So obviously you can go into a 482 visa with one employer, and then if you find another employer who is willing to sponsor you on a 482, you can move to them. But also at the same time, if you go onto a 482 visa, you can only work for your sponsoring employer. So you can't do any part-time work or work anywhere else, right? So what happened in this instance is when this client came, we really focused on, when clients usually come, what I tell them is, look, tell your employer if they sponsor you, they will secure your skills for the next 2 to 3 years because that's how long you'll spend on a 482. And secondly, you can always tell them, look, I'm already here. I've trained, I know how your business works, I know your clients. So sponsoring me is going to be far cheaper than hiring somebody new and training them all over again, right?
It's going to be like an extra cost to the company, extra time that they have to spend on sponsoring
Exactly.
another person.
So that has proven a very effective strategy. So don't ask for sponsorship at the outset. Of course, if your visa is about to expire and you need a sponsorship, ask them. But if you have time on your 485, I think the better strategy is to get into the business first and then work out a pathway with them after.
I think I'm quite sure when it comes to most of the employers, they're very unsure about how the process would work. They want to understand what their obligations are if they sponsor an employer. Let's say we get a client who wants to initiate a conversation with their employer. Would you help them strategize it, and how would you kind of help them? Would you speak to the employer and try to explain things to them? How would that process work at MJ Legal?
Yeah, definitely. In our consultations, what we do is we tell the client exactly what they need to know about the employer-sponsored process. So usually 482s, 407s have a 3-step process, right? So the employer must get a standard business sponsorship license. Then the employee needs to lodge a nomination application, and then only we can lodge a visa application. So I tell them everything, I outline all of the costs to them, and then I tell them, I'll send an email, forward it to your manager. So we have a good email that we will send out that outlines the entire process for your employer. And then I tell them, look, just book another consultation with your manager, and I will explain to them how easy the process is and what are the benefits of sponsoring you. And I've done that for many employers where I've convinced them to end up hiring or sponsoring our clients, and that has worked out pretty well. We don't do recruitment, but we're more than happy to have a chat with your employer and help them convince them to sponsor you.
So in season 1, I think we discussed about employer sponsorships in detail, so our clients can always go back and have a look at it. And today's session was very comprehensive. It was very helpful, Kate. Thank you very much. It was a pleasure having you here today. That's it for today. That concludes the season 2 of Visa Game Plan. Thank you for following us.